Okay, maybe the background to that case is that.
No, I'm now.
Yes.
I've moved from the case. I've moved from the case. I'm now asking, how do you justify a statutory approved collection society to which artists money is paid? Because if it is a violation of, if you assume it is a violation of rights, then the state has to justify. So I want you to tell me under Article 24 how we justify that violation.
Okay, rights can be limited, but the way you limit it, it also has to be justified that because of ABCD, we are limiting your freedom of movement the same way we have the COVID pandemic. Your freedom of movement is limited to these particular hours. So for this copyright, the statutory provisions, already, okay, I know you don't want to look at the case, but already those ones who are collecting were also provided by the statute. So there were two different statutory collectors. The artist had a right to, because you are many, you go and sign an agreement with the collector A. And this is the Dunda tunes, I think, where if the mobile rings, somebody is talking, so maybe the musician is singing. So already I have my collector. You are limiting my right to have that collector. You are now imposing another collector. If you read the law, this was a new introduction. And they were saying there was no public participation. I know Justice Mumbi Ngugi had dealt with the matter and declared that section not unconstitutional. But my view, the way the matter came was that you are now being forced that instead of using your existing collector, go to this. To me, I thought that these are just another way of limiting this.
So I want you to tell me how it can be justified. How it can be justified.
It can be justified maybe just to say for purposes of formalities, so that all of you are put in one section, one collector, or a specific number of collectors. Maybe these people, the way they will be taxed, the way taxes will be collected, we think that all these musicians should use this. There could be some parameters of limitation like tax collection, maybe compliance with the statutory provisions. These are the collectors who have been licensed. Maybe if you are many, there will be a problem of compliance. So to some extent, it can be limited.
Okay. Next question. The Supreme Court plays a very important role in devolution, and that is one of the key areas of jurisdiction of the Supreme Court. Can you tell us, identify any two pillars of devolution in the Constitution and why you think they are important?
Okay. The first pillar of devolution is the right to govern yourselves, so that those who felt that they were marginalized can now say that we are running our own affairs. So that is one aspect of devolution, and it has some historical connotation. The other pillar is the distribution of our finances and the economy. So the distribution of wealth to cascade down to the world level is part of the devolution objective.
Okay. So having identified those two pillars, how has the Supreme Court supported those two pillars? And you can cite specific cases. And
there is the case of the Speaker of the Senate and others versus the National Assembly, where the Supreme Court was called upon to decide whether the Senate has an input in the Division of Revenue bill, which had been passed by Parliament. And the Supreme Court said, yes, it's not that the Senate should wait for the division of finances amongst the counties, but it also has an input in the Division of Revenue bill. I think that is one aspect I can look at and say maybe that is the only case I can say.
Okay.
Yes.
Finally, international treaties, and we agree, international law is part of the law of Kenya. International treaties play an important role in protection of fundamental rights and freedoms. Can you tell us any African treaty that is applicable in Kenya that is important in terms of underpinning this Bill of Rights?
Okay, we have the African Charter for People, which was Kenya is part of it. So that one follows the International Covenant on Civil and Political Rights to some extent, but I think that the African Charter of People and Human Rights has some connotation of.
Okay.
Yes.
And what is the enforcement mechanism of that treaty? Briefly explain to us.
Okay, these treaties, states are called upon to comply with the provisions of those treaties, and the enforcement mechanism is by periodically reporting periodically reporting if you have assented to the treaty, so that you file periodic reports, just like the UN, you have to file your report on human rights, other civil liberties. So there are those periodic reports the state through in Kenya, the Office of the Attorney General. They file these yearly, either yearly or biannually. I am not so sure about that, but there are those reports. But there is also the court, like we have the court in Arusha. If in case there is anybody complaining, then that dispute can as well be another way of enforcing the law.
Any case of note concerning Kenya?
For Africa, I would look at the one which dealt with the decision of Honorable Martha Wangari, and then there is the one of those people who live in the forest, who went to that court, and Kenya was told that you have to leave, you have violated their rights.
Okay, thank you very much, and thank you, Chair.
Thank you very much, Honorable Judge Majaja. Thank you, Your Honor. I'll now request Commissioner Macharia Jero to ask his questions. Commissioner.
Thank you, Chair. My Lord, just a few questions in view of the fact that we interacted more comprehensively in the last interview. Now, the first question. Next year we'll have an election, presidential election, and of course, if there's any matter to be decided regarding the election, it has to be at the Supreme Court, where you would be if you go there and become a judge. Now, we are all alive to the fact that there's that tendency of the general madness that engulfs our country every time there's an election. Now, which leads me to the question, as judges in the Supreme Court, you being one of them, what do you think it would take not to be influenced by external factors, the prejudices, where everybody, you'll see that everybody becomes affiliated to a certain political thought. You are supporting a certain cause which could end up now influencing even the way one is taking a position in the Supreme Court, where you find that rather than providing guidance that is purely, dealt with in terms of the law, facts, evidence. There are also other prejudice that could also come in among the judges when sometimes they bring in divisions even amongst them. Now, I'm not saying that has happened before, but I'm just putting that as a scenario. What is it that you would say it would take for judges to decide a matter, you know, devoid of all these external influences?
The determination of a presidential election petition is a constitutional requirement under Article 140. So, not even an election petition. Every case, most of the cases have some external factors, external push. There are those for and there are those against. So, as an impartial arbiter, you are not saying you block your ears, but it's presumed that you are not hearing those factors. You are living in the community. You can open your WhatsApp. So and so is saying this, another one is saying that. But when it comes down to hearing and determining that case, what will be at play will be the documentation presented before the court. Note the stories you read in the newspapers, note the views of people you are watching on the television. So even if people, the judges, you know, everybody has his own opinion, not because he's a supporter of a certain political party, but it's because of his or her understanding of the case. So I don't think there is room to be influenced by external factors. We are there to dispense justice, and we will evaluate the case and do justice to that case.
Now, then, when it comes to the issue of external influences, now let's forget about the presidential election matters. Even in general disputes that would come there, where you could find that there are prejudices, maybe because of the way you've been brought up, probably because there are certain beliefs that one has, you know. How do you marry that with when a matter comes where there could also be different positions that are taken by the different judges you'll be with in the same court? How do you marry that and ensure that at the end of the day, whatever ultimately is the basis on which a case is decided is not on these prejudices of the different judges who could be in the court?
That is in line with what Madam Chair Commissioner asked, that now that you are there as a judge, how will you assist in handling some of those cases? You know, now you are putting me in a position where I can see so and so is prejudiced or biased towards this, but I don't think that would happen. If I'm there, all what you need to do is you have taken an oath to dispense justice. So dispensing justice means you are impartial and non-partisan. Being a judge of the Supreme Court, where the responsibility is much higher because the task at hand, when it comes maybe to the presidential election or to even any matter which reaches that court, I would say that negotiation and trying to reach a unanimous decision without infringing on the views of others will be maybe the most important thing to do, at least to try to harmonize. But if somebody is of a contrary view, what is his position and why does he have that position? One. Two, will also be guided by precedents. We have had several cases before that court, and we will see what the court has said in the past and try, although the court is not bound by its past decision, but we can see those cases as guiding aspects of determining future cases.
Now, the other thing is about the development of jurisprudence. Because you see, we are a country also, I think, based also on training at the university and law school. We have this tendency of relying heavily on common law. And of course, this common law, as we know it, was developed elsewhere. These are traditions and practices of another country, United Kingdom to be specific. Now again, when you come now to Supreme Court, you'll see that one of your requirements is also to develop our own jurisprudence, guided by our own traditions, our own practices, our unique circumstances. Now, I'm not sure whether that the Supreme Court has been able to realize so far. The jury is still out there. I'm not saying that they've not. But what role would you play in ensuring that even as we develop that jurisprudence, not that we'll ignore what has been decided elsewhere, we are, as legal practitioners, we are very good at quoting decisions from other jurisdictions. But what steps would you take, of course, in a collegial manner, to ensure that we have this jurisprudence in accordance with the expectations of the law that is also suitable to our circumstances, not relying on jurisprudence and circumstances of other jurisdictions?
Thank you, Commissioner. It's very rare to get a legal issue which has never been tackled in this world, that this is quite unique. Even if a case of COVID is filed today, it must have been filed elsewhere and a judgment or ruling rendered by another court. So we cannot operate like we're an island. So even the jurisprudence which we want to develop within our country, I'll give an example of the declaration that the mandatory death sentence is unconstitutional. If you read the Murwatetu case, the court elaborated other similar circumstances in Uganda, in other countries. So, although we want to say we want to have a home-brewed jurisdiction, but to some extent, you'll have to see what others have said. So if we are there as judges of the Supreme Court, it has been there for less than 10 years. When you talk of Marbury versus Madison, this is a case which is over 200 years old. So you cannot say that within 10 years we can pick and say this is the Supreme Court jurisprudence which has been developed within time. The common law we are talking about, how old is the common law? Many years. So my view is we have to give that court time. And the jury out there is, we want quick fix. So how do you develop jurisprudence within a short time? Jurisprudence is something which grows slowly as the cases emerge. And as they are developing the jurisprudence, there will be criticism. Maybe they will feel that the criticism is well-intentioned and veer towards another legal line. So by the time the court finds its direction, maybe it's 20 years. So let us give the court time. We are in a hurry to judge them. Or these judges, where is the jurisprudence? But the cases which have been taken there, they have handled them. They have given advisory opinions which have been useful to this country. They have handled 3 election petitions which form part of our jurisprudence. For instance, the standard of proof in election petitions. Although they came in with these not below balance of probability or not equal to beyond reasonable doubt, but that aspect has also been dealt with by other courts in India and other jurisdictions. So to develop your own homemade jurisdiction and say this is unique to Kenya, it will take time.
Okay. Now my last question, this is now nothing to do with the jurisprudence, is that there's no doubt, I must say that you write very well, when you look at your decisions, very well researched. They've captured the legal authorities, the facts, evidence, and you're also bold. You've made decisions without fearing the criticism and all that, and you think well. Good material for Supreme Court. But now, then the question would be that probably somebody would say that you need to wait a little bit longer. You are young. You give chances to others who have been there a little bit longer. Probably move to the next level, Court of Appeal, and develop more jurisprudence, then before you can take you to the Supreme Court. I don't know what would be your response to that in terms of, when you balance yourself. We are now dealing with practical issues here. Sometimes the commission, we must also be practical about dealing with the various, when we retreat to make those decisions of who we give, sometimes we look beyond that very sharp judge who is able to make very good decisions, but we say, goje kidogo labda tutaangalia maneno yake baadaye. I don't know what you would say about that. Thank you, Chair.
Okay, thank you, Commissioner. Now it goes back to the qualification. Have you done 15 years? Yes, I've done. Even the CJ can